Thank you for the introduction, John. My name is Sarah Rock. I'm a Senior Associate with Gowling WLG. Haven't always been a lawyer. I started my career as an electrical engineer. Learnt to draft on a drawing board, pen and paper, and then progressed through to 2D CAD, and then wisely got out of this industry before it all got very sexy and exciting and BIM came around. I moved into the legal world. Started out as a disputes lawyer. With my technical knowledge, it's quite helpful for defects. But then as BIM has come through, I've moved to be front end. So I'm now a transactional lawyer, drafting contracts, appointments in your case, mostly I think, and BIM protocols, or trying to. We're kind of making it up as we go along, I think, at the moment, most of us. So we're getting there. It was interesting what John was just saying about there's a lack of understanding around definitions of things such as BIM Level 2. I think this is possibly the closest we've got to it at the moment, the 8 pillars. Mostly all techie documents, apart from me, I pop up at the end under the BIM Protocol. And I think one of the reasons that the definition of BIM Level 2 isn't quite there is that I don't think we're quite there. PAS 1192 suite ends at 5 here. I understand 6 and 7 are to follow. So do we then update the pillars? Do we then need to update the definition? I feel it's a bit of a moving animal at the moment. So I don't think, well, maybe we can define it. It would be helpful in contracts, I have to be honest. If we're seeing them and people are promising that they will deliver to BIM Level 2 and not defining that, that could literally mean anything. And people excusing their liability for the computer standards of BIM Level 2 could mean even further. So we're looking at that. And myself and another BIM lawyer specialist, I don't know if you may have heard of her, May Winfield with Carillion. May and I have got together and we're doing a project with the UK BIM Alliance, which I think you've heard about this morning. And we are, initially, we've put out an online survey to ask lawyers and non-lawyers what experience they've had, how many projects they've worked on with BIM, if they've used contract docs on BIM, if they've used protocols, if so, which ones, why, if they haven't used any contract terminology, why not, and which aspects of projects are they using it on. We're then going to collate those results and have a look at them. But we really don't want to produce another 58% you do this and 60% do that. We really want to take it a little bit further. So later on in the year, we'll be looking to do some one-on-one interviews with people if they're willing to come and talk to us. And we'll look at what they've used, look at what's working, what isn't working. And the plan is for us to produce a strategy paper. Q1 is still our aim next year. To come up with some suggestions about how the legal world can help. And we think already one of the things that can help is better knowledge in the legal community. May and I are aware not all lawyers are BIM savvy, they're not all BIM'd up, they're getting there. But we're wondering about maybe some extra training for lawyers around BIM and the technical aspects. There's a few nods going on in the audience right now. Or maybe even different documents, excuse me, or different contract amendments. We're not too sure what the strategy will be, but we'd be grateful of your assistance. Please fill in the survey. It's on the BIM Alliance website. And then alongside that, but as a slightly separate project, May and I are setting up a BIM for Legal group. And that's where we're going to try and help the legal community understand a bit more about BIM. So we may be tapping on your shoulders shortly to come and explain your side of things to the lawyers, which I don't think ever really happens. And it's about time it did. So there's a few things going on in the background. But I'm going to talk to you today about how I would approach or how we approach a project as lawyers, a BIM project. So we kind of work our way around this circle. Aspect number 4 has come in the last month. We finally have a tiny piece of case law on BIM, which I'll come to shortly. But working around, my first question to a client is why? Because clients have many different reasons for wanting to use BIM. I think the dream would be they want a design and asset management tool, so we're getting the full service, the real full benefit of BIM. Isn't always the case though. Some clients want to use it for design collaboration. Some want some jazzy virtual reality model that they can sell the project to over in Malaysia or Russia or somewhere else, and they're not having to get clients to come here physically. There's many, many different reasons. I think the worst one would be I've been told I have to, because that project is probably not going to work. But the government mandate coming through, it's really helping. It's pushing it through, and we're seeing it come into fruition more and more in the private industry now. So once we've established why we're using BIM, we then look at the different procurement routes and ways of bringing BIM through into the project. Positively this year, we've seen JCT publish, well, it was late last year, and NEC4 publish with BIM amendments in them. They're a step forward. JCT allows for the use of a BIM protocol. There's a couple of little aspects that need to be caught in there, because I think the JCT docs think the BIM protocol does something it doesn't, and it knocks something out of the JCT suite in its place. So if that's being used, I would advise a little bit of caution just to check that through. NEC4 has been written in an international aspect. It interestingly doesn't allow for a protocol, and it doesn't really use the term BIM. It's movement forward. How helpful it will be, I don't know, but it's trying to cater for lots of different projects, as NEC does. Excuse me 1 second. They are a step forward, though. It's going in the right direction. It is new to everybody, so it is being embraced, it is being used. And I think as projects progress using these new forms of contract, we'll learn to amend them into a more standard form way, I think. Other contractual aspects we're looking at is the tender process. So, I mean, if you guys are mostly structural engineers, I think. So if you're producing a model to be given to the contractor at design process, what then happens to that model? Who then takes that through? It's an interesting point at the moment. One of the things I'm quite interested in is the overlay of the old with the new. So the contracts have a lot of old terminology in, and we have a lot of new BIM terminology. A lot of these things do the same thing. But a lot of people don't understand the connection between the two terminologies. So there's an example I've got on a later slide of the model production delivery table and the design responsibility matrix and the information release schedule. They're all kind of interlinked, but if they're not really matching up, and we've got different names for different things, and people think those tables are all doing different things, we really need to focus on making sure we're all talking the same language and just having that conversation, ask that question. Other things we've seen at the procurement stage, interface between multiple contracts and multiple models. So I worked on a very large BIM project last year that had 9 main works contracts. They're each producing their own model, and then those models all have to talk to each other. So you've got your individual 9 silos, and that's fine. They can all talk to each other within the team and produce their model. But how those models all then talk to each other and how those contracts are all linked, and it makes sure the models are all linked, is something we're working on, I think. It's coming through. So once we've looked at the procurement aspect, we'd look at the contract architecture. So this diagram is how I've tried to download my brain of how I think the legal structure works. I tend to work client side, so I'm sat at the top there with the employer. What the employer wants from the BIM model should go into the employer's information requirements. They can use an information manager to help them do that. So that's kind of the structure of my diagram. So then the contracted consultants, in your case, reply to that document with the BIM execution plan. Kind of use the analogy of the design and build ERs and CPs. I think they're the ERs and CPs of the BIM world. So the employer's putting in there what they want. Contractor consultant team are putting in the BIM execution plan, how they'll deliver it back. And then perhaps more importantly for you guys as consultants, that flows down into the BIM protocol. So we take out the crucial aspects of both of those documents, put them into the BIM protocol, and that then will get attached to a consultant appointment. So everybody should be singing from the same hymn page, is how the theory should work. The BIM protocol, we have one standard form in use at the moment in the UK, which is the CIC standard form of protocol. It's currently going through an update. My view is the construction industry loves a standard form, so I think we should get a standard form, and then everyone has their set of schedule of amendments to it. It's a slightly backwards way of thinking, but I think it'll help to move things forward. People are used to doing it that way. I've only really worked on bespoke protocols personally. I haven't used the CIC protocol through client choice, not through my own choice. And they work equally as well, but they're all very different, but maybe they need to be at the moment as we're still finding our feet and everybody's models are very different and everybody's requirements are very different. One of the reasons I think clients might be shying away from the CIC protocol is it is one size fits all. So it has to work with JCT language, it has to work with NEC language, it has to work with FIDIC language, it has to work with anything else, and it has to be incorporated in. So that kind of takes a little bit of amendment each time to make sure it fits with how the contracts work and how the contract terminology works. Also in the CIC protocol, the protocol makes itself the priority document. So for me as a lawyer, having slaved away for half a year negotiating a contract, this contract comes in and trumps it completely. Whether that should be right or not, maybe it should trump it just in a BIM dispute. I'm interested to see when the next turn of the protocol comes out, how that is addressed. And also the CIC protocol qualifies certain aspects. So consultants and contractors would maybe have their obligations watered down slightly through the protocol. So in certain parts it says you'll use reasonable skill and care to do this, you will use reasonable endeavours to do this. If that doesn't match up with what's in the appointment where there might be absolute obligations, which document has priority? And at the moment it would be the CIC BIM protocol. Protocol can always also allow for responsibility for the supply chain. So if we've got a lot of SMEs who aren't BIM ready, should the responsibility be on the tier ones to pick up their designs and put them into the model? Or does that then fall onto the client? Does the client pick up the responsibility for smaller members lower down in the chain not being BIM ready? Who takes that risk? Who carries the cost of that? I think those things ought to be ironed out in the BIM protocol so everybody knows where they are from the start. And then the final point that I put into my protocols is who's responsible for managing and hosting the common data environment. Which leads me nicely on to Trant and Mott MacDonald. So Trant and Mott MacDonald is, this is an interim injunction, so the dispute between the parties is not resolved to my knowledge. I'm not involved with the case, I must say. I'm taking this from the judgment as it was published. Trant were the contractor, Mott MacDonald were the consultant for constructing a power station on the Falkland Islands engaged by Ministry of Defence. Quite a big project. Trant took Mott on in the initial stages to do some small design elements with a view that if Trant won the tender, they would take Mott on fully. That happened. Two parties were working together, negotiating a contract as they went along, which never got fully completed, was never fully agreed. And as tends to happen, parties fell into dispute about payment, contract terms, who was doing what. And so the dispute rumbled on. Interestingly, in the contract document that had been kicking around was a limit of liability on Mott MacDonald's part of £1 million. The dispute rumbled on, as I said. Mott MacDonald were responsible for implementing BIM on the project and, as it would seem, hosting the common data environment. They'd set the common data environment up, Trant had access, documents were flowing around, the dispute came to a head and Mott MacDonald withdrew the passwords for Trant, so Trant could no longer get into the common data environment. They then brought the interim injunction to say, if we have to start a new common data environment now at this stage in the project, our losses are likely to exceed the £1 million liability. Mr. Judge, can you please, actually it was Mrs. Judge, my mistake, can you please get the CDE access revoked? Mott MacDonald said it wasn't fair, they were owed too much money. The judge took the view, Trant had to pay into court, I think it was about £500 million, and Mott MacDonald had to revoke access. One of the interesting factors was the documents had already been passed into the shared area of the common data environment. So it's almost, if you think old school days, I've done my design, I've given it to you, it's on your desk, and then I've fallen out with you and I've come into your office and taken it away. And not only that, I've taken everybody else's designs away, because in the common data environment there was other design data. So the case has opened up a bit of thinking about who should host the common data environment. If there's a bi-party disagreement, so I've employed John and Nigel, and I have an argument with John, he can't take Nigel's work away as well. He might have contractual rights to take his own work away, but he can't take anybody else's work away. Who should host the common data environment going forwards? There's different ways to think about it. So I've taken this from the 1192 excuse me, scheme of docks. And a diagram, I don't know if you guys are familiar with it, it starts up in the top right-hand corner. So you have your individual teams working up there, individual teams work in progress. They move their work through into the team shared area, all the team can see it. When they've decided it's ready, it pushes down to the client shared area. If the client's not happy, they send it back. If they are happy, it stays there. One way to think about this is the client hosts the whole thing. That way, nobody can turn the client off. Nobody can take their access away, and nobody can revoke their access. I wonder how many clients have the capability, the understanding, the technical people to host the common data environment and make sure this system is set up in place. There may be some, I don't know. Another way to do it is to allow a consultant to host it all fully, and the client could take a copy, but it seems a lot of work. How this works, how it works best is unclear. One way we came up with doing it for a very large project was we split this diagram right down the middle. Anything above this line was hosted by the team. Anything below the line was hosted by the client. That way, once anything's been passed to the client shared area and it's useful to the client, no one can take it away from them because it's in their cloud. Any work that's happening before that, the client really doesn't care about anyway. So that might be a better way to do it. And we split it that way through drafting in the BIM protocol. So that might be something that I think this case might lead to more thought about and excuse me, more drafting to allow for that. Final points on this is just a few legal considerations to consider for consultants. Skill and care is quite an interesting one. I've seen some consultants offering the skill and care of a BIM structural engineer, for example. Is that different to a structural engineer? Are there now BIM accreditations and BIM courses that mean you are performing to a different standard? Should you be performing to a different standard? We don't really know yet, so I'd exercise some caution in what you're signing up to on the reasonable standard of skill and care. There isn't a standard at the moment for BIM consultants of any degree, whether they're architects, project managers, structural engineers, contractors. There isn't enough case law, there isn't enough understanding out there, so I just exercise caution initially. I was talking about BIM accreditation courses, BIM certification courses. We're seeing more and more coming through. What value they add to you as a consultant would be interesting. I'd look at the standard of the courses, what it is that you're signing up to. Do you have to display certain knowledge? Is there tests involved? Because I think even the standard of the courses is going to be flushed out as we progress forward. Excuse me a second. Further consideration I would look at is consistency of services across the team. So, and this kind of sits with overlapping of design responsibilities and coordination of roles. So looking at consultants' appointments on BIM projects, we're seeing some things are repeated and some things are missed because there's new things involved and no one's really sure whose responsibility it is. It's not the lawyer's role to look at the services as it's technically a technical document, but I advise you guys to have a look really carefully and make sure it is spelling out exactly what it is you are doing or what you think you're doing. And if it's fuzzy, for example, if the services say you will provide BIM Level 2, I'd be really questioning that. What does that mean? What is the client expecting? It might be the same expectation that you have, but unless you have the conversation and you ask the question, it's not clear and nobody's clear, and that's when disputes can come about. The misunderstanding can lead to real problems happening. The role of the information manager is introduced through the CIC protocol. I think it's a valid role. Somebody in there managing the BIM process, maybe they should be the guys managing the CDE process, depending on how that CDE diagram is split eventually. But are you being expected to be the information manager? Is that in your services? Do you know who is the information manager? Because you're going to have to work with them if you're producing a model. How the model will be viewed in 5 or 10 or 20 or 50 years' time. If one of the aspirations of BIM is to produce a model that can be used for the asset lifetime of a building. How long is that? Is the building expected to last for 80 years, 100 years? How will we view the model in 5 years' time, in 10 years' time? If you think about VHS, DVD, online streaming of films, technology is just flying ahead at the moment. So again, I would exercise caution saying that the model you give to somebody tomorrow can be used in the same format in a year's time, 2 years' time, 5 years' time. Technology is changing, and how we interact with these models is going to change significantly, I think. Whether we end up Minority Report style, who knows? Some of the VR stuff is getting there, some of the AR stuff is getting there. Again, I just exercise some caution. I'm trying not to be the voice of doom and gloom, but just the voice of reasoning, and just have a think about some of these things before you're signing up to them, or get your lawyers to do it. Cyber security, if you're working on a sensitive build, if you're working on a high-risk build, public interest, research and development facilities, making sure your cyber security is in place, making sure your servers are safe, your access to the cloud is safe, and that you can sign up and guarantee that. If you're unsure on that stuff, I'd have a look at PAS 1192.5, which has got the cybersecurity information in it. And then again, the old and the new terminology, which I've spoken about earlier. Just make sure any terminology in the appointment matches up with any of the BIM terminology, or there's definitions that link the two terms. So everybody knows what they're talking about. Documents includes the model, it includes the data, it includes anything you think it should, or anything the client should think it should, or have that conversation. I think it's opening up the dialogue and asking the question, but stopping to think before signing up to various things. We have seen a lot of definitions of BIM Level 2, or at worst undefined, so just make sure everybody knows what they're talking about, everybody's coming from the same page. So I think BIM Level 2 is coming through, it's being seen more and more. A lot of projects aren't hitting BIM Level 2 from our experience. They're getting there, but they're not quite there. I personally don't see anything wrong with that. It's a learning progress, it's a staged progress. And if you're not hitting BIM Level 2, does that mean you're not doing BIM? I'm personally of the view it's okay. It depends what the client wants, surely. We go back to that first slide. Does the client need all singing, all dancing BIM Level 2? If so, brilliant. Everything's there to help you take it through. But if they don't, perhaps over-egging the pudding perhaps wouldn't be that helpful for that client. But clients are looking more now towards BIM Level 2, and we are trying to make BIM Level 2 business as usual. It will come, but at the moment, if the project isn't BIM Level 2, I don't think that's anything to sort of be shy about. As BIM Level 2 goes forward, we'll be looking towards BIM Level 3, which has huge, huge implications for the legal world from my point of view. I was explaining it to somebody who didn't really understand BIM the other day, and I said, BIM Level 2, I've got 10 pieces of paper and 10 pens, and I put the pieces of paper on top of each other. BIM Level 3, I've got 1 piece of paper and 10 pens. Who drew what and when, and how do we trace that back? From a legal point of view, for IP, copyright, for liabilities, I think all that stuff really needs to be thought through. But it is coming. This slide shows that my childish thinking of the analogy of BIM Level 3. Who in the room used to play with Lego when they were a kid? Okay, I want to play Lego with Anne, so I've got to call Anne up. I've got to physically go over to Anne's house. We'll build something together, and I go home again. All good. It was good fun, right? Who in the room plays with Minecraft? Who knows a child that plays with Minecraft? So Minecraft, Anne and I, can be sat in different rooms, different buildings, different cities, different countries, different continents, building in the cloud at the same time before we can go and shoot the zombies. But we're building in the cloud. It's Level 3 BIM. They're in there together at the same time, they're being collaborative, and they don't even know it. So by the time that generation comes through, BIM Level 3 will be first in their thoughts. They'll be wondering why we haven't been doing this for years, because they'll be so used to it. They're part of that digital generation who just collaborate online without thinking about it. So I think that next generation coming through against the older school generation that might still be in existence. It's going to be an interesting little battle to see how that goes through. And that's me.